All right, so that's the prosecution's response, and we hear them talking about the credibility of witnesses that testified during the trial, and about these notes, which came from Dr. Diamond, who was the memory expert called to the stand during this, and he was also called to the stand during the hearing, I believe, on Tuesday as well as Monday. So, Holly, when you hear the prosecution's response, you heard the defense and what they had to say. If you had to guess, do you think that Harris will get a new trial here?
I think that the trial court's going to deny the motion, and I think it's because the trial court has broad discretion in these circumstances. So basically, what the defense is complaining about is that the objections they made at trial or the evidence they were trying to get in, the court did not go their way during the trial phase. And whenever the defendant's asking for a motion for new trial, that means they're asking the same trial court to overturn the decision. And, really the state of Georgia deters a lot of people from doing that. So you have to show a real abuse of discretion. In fact, I think the legal standard for the admission of the prior bad acts evidence and some of these evidentiary rulings, for example, excluding some of, I think actually the defense made some objections or chose not to have Dr. Diamond testify fully because they had to turn over their notes. And really, I think it's going to be an uphill battle for the defense simply because there's such a broad discretion given to this trial court to make her rulings. And the other thing that I think is really interesting, and this is something that happens in trials all day long, you have these pros and cons of introducing your testifying experts. So if you're going to put someone on the stand that's going to say a very important piece of the case that helps the defense, then every attorney knows you have to turn over the report and the work file that goes along with that opinion. That's the whole point of designating an expert opinion instead of having that person just be consulting with you behind the scenes. So I think it's really interesting, and it's a tough decision for defense attorneys to make all day long about whether or not they're going to introduce an expert witness if there's damning evidence in any of those written files or audio files. So I really enjoyed listening to the prosecution's closing because it was highlighting to the court and to the public why those notes are important. And if you're going to offer that person as a witness in your case, you have to explain what their notes say too. It's the good and the bad.
And one of the things we saw during this was the fact that the prosecution was trying to kind of build this case around Harris, that he had these web searches that kind of led to him having this bad behavior going on the internet. They also were trying to say that he was, not faithful and had all these other side things going on. Do you think that they had the evidence to back those up?
Absolutely. I mean, this case was 22 days long. They had both, over 70 witnesses total. And over 22 days, they even changed the venue to make sure that they were going to get an impartial and fair jury. And so when the court allowed the evidence in of Mr. Harris's prior bad acts, sexting with 8 different women, including an underage woman, writing down in the morning that Cooper died, writing down, if it weren't for my son, I would totally escape this life, or something along those lines. And so at the trial court level, when you have that evidence that is not necessarily about what happened that morning, but could provide context for a motive, the trial court is asked to make a decision about whether or not that evidence has any probative value, meaningful, relevant value, and that probative value is not outweighed by the salaciousness of that evidence and the prejudice that would have on a jury. And I think that because this evidence went to the motive, and that's exactly what Lisa was talking about earlier, that 56%, and the remaining percentage are the people that actually did it intentionally. Because the jury was asked to walk that fine line, determining whether or not Mr. Harris intentionally did this or not, all of the evidence about whether or not he had a motive for this should definitely come in. So I think the trial court got that right. And finally, if the defense had such a problem with it over, 22 days in trial and at least half of the 70 witnesses, I think they could have fleshed that out a little bit further and talked about whether or not that evidence was true or whether or not there was bias in that. And so it's a tough call, but I think the trial court got it right at the trial court level about those prior bad acts.
All right, Holly, thank you. We will have to see what happens. We're going to talk more about this case after the break. Stay with us here on Law and Crime.